In the previous videos, we have identified a huge area of Islamic law called ibaha, or the area of permissibility. We have also termed this area as the uncharted area, the flexible sphere, and the area of siyasat sharia on different occasions. This is an area in which the texts do not expressly lay down the law. Where express texts exist, the jurists have been able to derive rules for obligations, recommendations, prohibitions, and disapprovals. It is true that some of the rights that we term human rights may be linked to these obligations and prohibitions, but the bulk of the rights cannot. To make laws in the uncharted area, the jurists have often referred to the original principle of permissibility for making laws. However, when this principle is used, we can never be sure that the norms of the Sharia have been incorporated into the rule adopted. To ensure that the rules adopted or created incorporate within them the norms of the Sharia, a new methodology was devised by the jurists. This methodology goes by the name of Maslahah mursalah. The methodology was developed by the illustrious Imam al-Ghazali. Initially, it was not accepted by some schools, but then it was realized that most schools follow a similar methodology, albeit under different names. The term mursalah means to release or to let go. This means that the methodology emphasizes that the specific or express texts have released their hold over the issue under consideration and have released it into the uncharted area of permissibility. The texts do not apply to the issue expressly, although they may apply to it in a wider form of implication, which will still give the norms a role to play in the formulation of the rule that will govern the issue. The wider implication or framework that will give the norms of the Sharia an active role in the formulation of the rules is provided by the maqasid al-shariah, or the objectives of the Sharia. As already explained in a previous video, the objectives of the Sharia are 5 ultimate principles that require the protection and preservation of the Islamic civilization, of human life, of the family unit as the organization for rearing children, of the development of the intellect or reason as vital for human progress, and finally of the preservation and protection of property for supporting all the preceding objectives. It is important to note that these 5 principles emerge not only from the texts of the Sharia, but are also promoted by rational proofs in a compelling way, as has been shown by the illustrious Imam al-Dabusi. The methodology called Maslahah mursalah mentioned above revolves around these 5 principles for ensuring that the rules derived will support the norms of the Sharia. We have indicated in a previous video that the framework of the objectives of the Sharia may sound tempting for some persons to use their unbridled reason to say, for example, that such and such a rule is good for protecting life, or is good for the family unit, or is good for the intellect. Hence, it should be adopted. This may be likened to people reading sound traditions on the internet and then, according to their whims, rejecting old laws or proposing new ones for us. To safeguard against this, the jurists laid down a clear procedure as to how the method of Maslahah mursalah is to be used in conjunction with the objectives to derive new rules and laws. For every new law that is to be created, the legislator or the judge, or the jurist or the scholar trained in some discipline may, when he is creating a new rule, have to first formulate the rule in his mind in the form of a proposition. This proposition must conform with the legal policy of the maqasid. It must not attempt to go against the implication of a legal text of the Quran or the Sunnah. And finally, it must be compatible with the governing general principles of various categories of Islamic law. Once the rule clears these benchmarks, the expert may go ahead and apply it to the fact situations under consideration. The methodology described above will be applied to 2 broad areas that are covered by human rights. The first area is where the expert is seeking to justify a right that is approved by the Sharia. He will see whether the proposition he has formulated has the strength to pass the benchmarks mentioned. If it does pass the test, he may assume that it is a right promoted by the Sharia and thus adopt it. The second broad area may acquire greater significance today. The methodology will be used to justify or reject, as the evidence indicates, a right adopted by the UN system of human rights. It will apply equally to individual rights as well as group rights. It is obvious that the expert using this methodology will have a basic knowledge of Islamic law and even of modern law or some modern discipline. Once a human right adopted by the UN system passes the benchmarks, it may be adopted as being compatible with Islamic law. Muslim experts must accept this task as a challenge.